It's been a while since this story first broke, but I'm back with an update as promised. I'm talking about the suit against Will Folks and Fitz News filed by Mark Tinsley on behalf of his client Austin Stanley, whose face erroneously appeared on Fitz News' website and social media platforms not once, but twice, even after conversations with Stanley's mom about the case of mistaken identity took place. For those of you who missed the first two episodes, I'll link them in comments, but today we're going to discuss the long-awaited reply from the defendants. Let's get started. This is Legal Updates with Cassidy. I'm taking accountability by denying everything. Welcome. The first step in a legal case is called the complaint and the summons. These are basic documents that list out the accusations being made by the plaintiff against the defendant. They usually include whether or not the plaintiff is requesting a jury trial, which in this case, they did. We've reviewed this document already, but we'll be looking at it again because the second step is the defendant's answer. These are also basic documents with just the necessary information in response to each claim laid out in the complaint. Some of the answers sound unnecessarily vague, but it's the nature of the theater we call the legal system. You'll see what I mean in a moment. What we're going to do today is a side-by-side of these two documents, keeping in mind that it's normal for these to sound vague and even argumentative. They basically want to admit nothing, and that's the whole point of the carefully worded replies. But this one goes too far. For a little background here, I do want to mention that there was some conversation that took place on X or former Twitter in which Will Folks said some things that he seems to now be taking back. For example, in this tweet, posted right after the suit became public, he says, "Hardly anyone takes accountability anymore." Remember that line, please. Or, admits to their mistakes. That one as well. An honest mistake was made here. And we apologized and did our best to correct it. But we will have to live with the consequences. Thanks to the Mark Tinsley and the Eric Bland for holding us accountable. Now let's see how he feels about that accountability in his answer today. So this tweet was a reply to a tweet that had been originally made by Eric Bland. So after criticizing others here for not taking accountability and thanking Tinsley and Bland for holding he and Fitz News accountable, one would get the impression that they're taking accountability, right? Well, we'll see how that plays out. At the time, Bland had called out some of the wording, such as, "An honest mistake was made here," instead of saying, "I made a mistake" or "we made a mistake." Keep that in mind for a few minutes too, but also, as mentioned in earlier podcasts, did they really do their best to correct this mistake? If the same erroneous picture was posted everywhere that Fitz posts several months after emailing the plaintiff's mother, is that really your best? Now we're going to look at this email again. We did talk about it in an earlier podcast, but this email was sent in April. Yet the picture was shared by Fitz News again months later in October, and this is where I feel there's clearly no defense. There's not an excuse for doing it a second time when you clearly know this is not him. But just like Eric Bland mentioned the wording of his tweet, let's look at the wording of this email. I was watching a behavioral specialist the other day, and they said something I thought was interesting about wording. When someone is denying culpability or saying something that they don't really want to say or don't believe, they tend to drop off the word "I" in a sentence. I had that fresh in my mind when I read this time. Tell me what you think. Here, he uses "I" when he says, "I did receive your messages." But when he's so-called apologizing for the late response, the "I" disappears. Just says, "apologize." Doesn't say, really, who's apologizing? I don't know what you guys think about behavioral science, but I just thought that was interesting. Now when he's talking about what was done to correct the situation, which is something that would put him in a positive light, the "I" is back. He wants to take credit for that, so he says "I." But when offering a solution and claiming to be happy about it, it's gone again. Isn't that interesting? Sometimes our words can be a big indicator of what we're not saying as much as what we are saying. But here we have a guy who wants people to believe that he's taking accountability. Let's keep that in mind as we cover these documents, as I said, side by side. But before we start, look at the top of the page. They didn't even get the spelling correct of the plaintiff's last name. It's not even a hard name. It's just Stanley. The first page is pretty basic. It's information about the plaintiff, folks, and Fitz News. That Stanley is a citizen of Hampton County in South Carolina, that Fitz News is an LLC with its principal place of business being South Carolina, that Will Folks is from South Carolina, and the document admits to all of it except for 4, that Hampton is the proper venue, which does not require an answer, but he does come back to that later. So now we'll move into the causes of action, with this first one being defamation. And these causes of action are the legal terms for what he's being accused of and why. So this first one is, like I said, defamation. Now 6 makes me giggle because I can hear Mark Tinsley's voice saying this. If you've had an opportunity to hear him speak or watch how quick his mind works in the courtroom, it is truly an art form. And though there's no way on earth you're going to get a defendant to admit to these statements, deep in my heart, I love that he says them. He says Fitz News is a news organization which many refer to as a tabloid because it monetizes and traffics in salacious stories to gain followers and viewership across multiple platforms, including its website, Instagram, Twitter, and YouTube. Furthermore, Fitz News and Folks tweet and otherwise post provocative headlines as clickbait to attract attention and promote their content. And of course, in the answer, the defendant admits that they're a news outlet and denies the rest. And the same with 7. Fitz stands for First in the South, which exemplifies the defendant's financial goal of being first to break stories rather than taking time to verify the accuracy of information before releasing it and refusing to consider the long-term implication of the extended reach and permanence of the publications they make. And naturally, they deny this as well, as expected. And as I said, we can expect everyone's going to deny those things. But here's where it starts to irk me. Because in this complaint, it states undeniable facts. In number 8, on or about April 1st, 2023, the defendants published an article identifying people that Fitz News contended were somehow involved in the murder of Stephen Smith, a 19-year-old gay man who was found dead in the middle of Sandy Run Road in Crocketville, South Carolina, on July 8th, 2015. Now this happened. It's not even really a question. It happened. There's nothing here for opinion. It's all fact. But here comes their answer. Defendants crave reference to the article referenced therein and deny any and all allegations inconsistent therewith. They crave reference to the article. Now, crave in legal terms means demand. So they're demanding reference to the article that the complaint is referring to, though there's a photo from it in the complaint. And Fitz News knows very well what articles these were. And then they have the gall to deny any and all allegations. Though these articles were widespread on social media, both on Fitz News websites, Twitter, and YouTube, it's indisputable. The same with 9. Number 9 says in the article and accompanying video, defendants published a photograph of 2 people defendants claimed were prime suspects in the murder of Stephen Smith. Again, fact, not opinion, but you get the same response from defense. Defendants crave reference to the article and accompanying video reference therein and deny any and all allegations inconsistent therewith. Now 10 comes along and makes me even more angry. It says the photograph of the individual on the right-hand side of the photo is Stanley, the plaintiff in this case, who had absolutely nothing to do with the death of Stephen Smith, who has never been a suspect or person of interest in the death of Stephen Smith, and has never been linked to the death of Smith other than falsely by the defendants and their agents. Their response? Defendants, upon information and belief, admit only that the individual on the right-hand side of the photograph is plaintiff, but nevertheless deny that he has never been linked to the death of Smith other than falsely by the defendants and their agents. Defendants have insufficient information to respond to the remaining allegations contained in paragraph 10 of the complaint. Now, this is where I think they're going to go down the road that some others also posted his picture. And if you go back to my first podcasts about it, you'll see that one of those persons did post prior to FitzNews posting, and that was Eric Allen. He did do a disclaimer later that this was not the suspect, and his video on it has been taken down. And since FitzNews posted the article, a lot of people reposted his information. And this whole bit brings up two things for me. One, did Eric Allen have a conversation with Austin Stanley's mom and then turn around and repost Austin Stanley's picture again months later? No. Apparently at some point, either by being notified by someone or by his own research, Eric Allen realized that this was not the person. He posted a disclaimer and later at some point deleted the whole video. I don't know when he deleted the video, but the second point is this. This story had just broke, and all of a sudden, FitzNews supporters had clips of Eric Allen having posted this picture in a video that had been taken down. Who had that screenshot? Did FitzNews base his whole story off of a picture he just got from Eric Allen instead of doing his own research? And that's how he knew to have someone post Eric Allen and say he did it first? Do you know what I mean? This popped up instantly. Oh, Eric Allen did it first, and yet Eric Allen's video had a disclaimer in their screenshot, and the video is gone. So how did these people know that it had originally been posted by Eric Allen if Fitz didn't just straight up copy it from him in the first place? It's all very fishy, but also the fact of how they dealt with it. Eric Allen put out a disclaimer, later deleted the video. Fitz gave an unapologetic apology and reposted the photo. It's a different story. Does that mean FitzNews should not be held culpable because other people did it too? Everyone else is doing it, why shouldn't we? No. But I think it shows one of the ways that they intend to defend themselves, so keep this in mind. Moving on to number 11, it says when the false statements were made about the plaintiff and his photograph was published, Stanley's mother repeatedly emailed folks and FitzNews and let them know that they made a mistake, since Austin has not and will never be a suspect in the death of Stephen Smith, nor has any law enforcement agency ever named him as a suspect or person of interest in the investigation of the death of Stephen Smith. And though the emails were written to and from the defendant's own email address, this is their answer. Defendants crave reference to the emails referenced therein and deny any and this time they forgot the word all. Why not just cut and paste? Your answers are all cut and paste. But deny any and allegations inconsistent therewith. You're going to have to excuse me. I'm having trouble finding all this accountability that he was talking about in his tweet. I think we might need a microscope to continue. And so it goes on with number 12, even though we see the very email in question right here in the complaint. It says, on or about April 4th, 2023, after the false statements concerning the plaintiff had been broadcast and published for days, folks responded to the message/email and acknowledged that the statement about the plaintiff was false. Stanley's mother was correct. Stanley had nothing to do with this story and promised this photograph would be removed immediately. How are they now craving reference to the email? It's right here. Yet the answer remains the same and is followed by another denial. The same response they post for so many of these. And though we have the thumbnail and a screenshot of the YouTube post, as well as the Twitter post, along with Claim 13, which reads, nevertheless, on October 9th of 2023, despite their acknowledgement about their false statements, defendants published another story, again indicating the plaintiff was a person of interest in the murder of Stephen Smith, and a photograph of the plaintiff next to the words prime suspects. On all of its outlets, including but not limited to its website, FitzNews, YouTube, and X, previously known as Twitter. Here's the proof right here in these pictures. Yet they dare to give the same exact canned response to this. Defendants crave reference to the story referenced therein and deny any and all allegations inconsistent therewith. I don't know about you all, but I am way past irked now. Let's move on to number 14, which says, these videos and publications constitute false statements which accuse plaintiff of a serious crime and which was published to the world. Again, this is a factual statement. This is not an opinion. This is not open for interpretation. This is exactly what happened. There's literally nothing to dispute. But here we have the response that the complaint states a conclusion of law which defendants are neither required to admit nor deny. They are running from accountability, not taking it. Number 15 is again facts. It says, according to the YouTube video, as of this date, that video received at least 151,000 views and has likely been viewed by many more. Furthermore, in the YouTube video, folks goes to great lengths to explain how seriously they take calling someone a person of interest and implying that means the suspect or person of interest was in fact involved in the death of Stephen Smith. And now this guy's like that mosquito that you hear screaming around your head when you're trying to sleep at night and you'll slap yourself in the face just to try to make it stop. Here he is again with the same thing. Defendants crave reference to the YouTube video reference therein and deny any and all allegations inconsistent therewith. It's your own website, FitzNews. Why are you craving reference? Moving on to the first part of 16. Now this one is factual, but the kind of fact that would indeed need to be proven in court with witnesses or affidavits or some type of evidence. I mean, we can all imagine that this is definitely what's happened to this young man, but on this one, probably any attorney would respond in this way. The complaint is, as a result of these false statements and publications, many residents of Hampton County who recognize Stanley's photograph have commented to him, his family, friends, and others about Austin's alleged involvement in the murder of Stephen Smith. The statements or insinuations cast plaintiff in a false light and were defamatory per se. And the response to that first part is defendants have insufficient information to respond to the allegations contained in the first sentence of paragraph 16 of the complaint. Like I said, probably any attorney would respond this way, but I'm still holding a grudge from all the others. But the last sentence of the accusation in number 16, we know as a fact from the email exchange. It says, defendants and their agents, servants, and employees actually knew of the falsity of the statements when they were made for financial gain. The response, the remaining allegations contained in paragraph 16 of the complaint, state conclusions of law which defendants are neither required to admit nor deny. So even though the email is there, him apologizing but not really apologizing to the mom, saying that he's done what he can to remedy the situation, yet it went out again. So in fact, they knew the falsity of the statement because they knew it in April and yet reposted it in October. You have an email admitting it in April, yet reposted in October. How are you denying it? Don't want to admit it. Number 17, again, we would expect this answer by any attorney. The accusation is that the aforementioned false and defaming statements were made with reckless disregard for the truth by the defendants and were published to multiple third parties. The third parties part is undeniable, but their answer is that it states a conclusion of law which defendants are required neither to admit nor deny, because naturally this would need to be proven in court, so I'll begrudgingly give them that. The same answer, but now they moved on to another canned response they're going to use multiple times in answer to the remaining points of this first cause of action, this same answer. And I'm not going to read it all word for word because, like I said, this was covered in my first podcast. But it's stating things like these were published with actual malice, the plaintiff has suffered harm, embarrassment, worryation, and injury, will continue to suffer such, and that he's entitled to an award. And again, if you want to hear those word for word, that would be back in the original podcast that's linked in comments. That takes us now to the second cause of action, and this one is negligence. Now for points 22 and 23, they continue with this number 2 canned response. And now we're going to need a telescope to try to find the accountability. I'm not going to read all these accusations from the complaint. Again, as I just said, they are linked below. I did cover this document when it first came out. But basically, it highlights all the ways the defendant failed to protect Mr. Stanley himself directly and through improper training and supervision of his staff, to which defense is going to give that same canned response to each and every one. Then we move on to the response to the demand for relief, where we now need the Hubble telescope to try to find the accountability, in number 26, where they just outright deny that the plaintiff is entitled to recovery. Number 27, they say each and every allegation set forth in the complaint fails to state facts sufficient to constitute a cause of action against defendants, and therefore must be dismissed. Not from what we were reading here. I mean, apparently this attorney can't read words or pictures. Number 27 just gets baffling. They lay blame on others without even naming who these others are, even though this man's picture was on their website, their Twitter, and their YouTube. It says defendants would allege and show that any injuries and damages sustained by the plaintiff as alleged in the complaint, which are denied, were due to and were caused and occasioned by the intervening and superseding negligence, carelessness, recklessness, heedlessness, willfulness, and wantonness, I love the word wantonness, of some other party or parties over whom this defendant had no supervision or control. They're laying blame on someone else's door. And defendant does plead such intervening and superseding negligence, carelessness, recklessness, heedlessness, willfulness, wantonness as the direct and proximate cause of the injuries and damage sustained by the plaintiff as alleged in the complaint. 29. Now here's where they set up the offset clause, where it seems they want to push the blame or share the blame with others in order to decrease the amount they would have to fork out if in fact they are found guilty. It says any recovery by plaintiff must be reduced or offset by amounts plaintiff has received and will receive from others for the same injuries. So this is put in there just in case there's guilt found. They really seem to think they can bring others into this to share any amounts that they would be required to pay. Then they spend a few more points trying to minimize any damages, claiming that defendant didn't engage in malicious, reckless, wrongful, or intentional conduct deserving of punitive damages. They request that a limit be put on any damages that might be awarded. They also reserve the right to request bifurcation, which is dividing of a case into 2 stages for trial. For example, a common division is to determine liability or guilt in the first stage and damages or punishment in the second. So you can see they've already got some methods they're intending to put into place in the case of a trial. Then in number 33 it states that claiming punitive damages violates defense's 5th, 6th, 7th, and 14th Amendment rights. What about Austin Stanley's right to not be wrongfully accused of murder? And now they start just throwing everything they can think of at this and hoping something sticks. They move on to spoliation of evidence, statute of limitations, claims that plaintiff didn't mitigate the damages, and I just want to say, hey, we crave reference to all these claims. There's no proof being offered about any of this. Number 37 is an absolute shock. Let me read that one to you. Any comments made by this defendant concerning the plaintiff were truthful and or not maliciously made and therefore are not actionable. You posted that someone is a person of interest in a murder. And not just any murder, a well-known murder. A murder that has been on countless documentaries around the world. And you claimed that he had something to do with the murder, not once, but twice, the second time after fake apologizing for it. How is this truthful and not malicious? A lot of things on this page made me furious, but this one I think makes me the most furious. The same with number 38. Any comments which have been made by this defendant concerning the plaintiff were made in good faith and with proper motives. Good faith involves checking your sources and not reposting a picture you know is the wrong person when you're accusing someone of murder. And good motive? What proper motive? The motive was money. The motive was growing your subscribers and viewers. I'm sorry, but that's not proper, and that's not more important than an innocent man's reputation. Number 39, plaintiff has failed to state any basis upon which attorney's fees and costs are recoverable against defendants, and therefore plaintiff's prayer for such damages should be dismissed or stricken. They don't want to pay. And believe it or not, he's still going just pages and pages of these little sentences. He now claims First Amendment protection. How many amendments has he claimed now? But listen to 41. The publications about which plaintiff complains was a fair and impartial report of matters of public interest, and defendants published the report without malice. The publication, therefore, is protected by privilege. Fair and impartial. How is it fair to post a picture and accuse a man of murder twice without proof, and the second time knowing it was the wrong man? How is that fair? 42. Any harm resulting to plaintiff's reputation as a consequence of defendant's publication was de minimis. This is something that's very trifling or of little importance. It usually refers to something so small, whether in dollar terms, importance, or severity, that the law will not even consider it. I don't think anyone on this planet would feel that their picture being posted and claiming you're a murderer, not once, but twice, in a huge internationally known murder case, is of little importance or trifling. Number 43 claims that he suffered no injury, even though he stated that he has, and clearly he has. I mean, imagine it. Imagine your face was posted on a local news outlet that's also been broadcast internationally, but in your small town. We talked about this before. These people know each other. They see this guy's face, they know exactly who it is, and they're claiming he suffered no injury. Number 44, they're repeating the claim that it breaks his First and 14th Amendment rights. And 45, they take issue with the venue, saying that defendants contend that this matter was commended in an improper venue. Defendants do not waive and specifically reserve the right to move for transfer of venue in accordance with Rule 12b-3 of the South Carolina Rules of Civil Procedure. How is this an improper venue? And they finally end this with asking that the case be dismissed. Not just that, but they ask for costs and expenses. Now on April 25th, Mark Tinsley basically said, nonsense, and filed a motion to compel demanding costs and expenses. And on page 2, he basically says, quit playing and give the court honest answers here. By saying that the plaintiff in this case alleges that the defendants in this case committed both defamation and negligence when it published multiple photographs of the plaintiff with the words prime suspects underneath the photograph of the plaintiff and his friend. There cannot be a dispute as to whether the defendants published this photograph as it appeared on the defendant's website, Twitter account, and YouTube page. The only issues in dispute are whether the picture was negligently published and whether the picture constitutes defamation under South Carolina law. On February 26, 2024, in an effort to simplify the issues in this case, the plaintiff served 5 requests for admission on defendants Will Folks and Fitz News. Each of these requests was for readily apparent information which cannot reasonably be disputed in this case. The plaintiff seeks an order compelling proper responses without objection to the below 2 requests. The requests for admission and the responses of these requests were as follows. 1. Please admit that Fitz News published a photograph of Austin Stanley with Stephen Smith and that the photograph included the text prime suspects as seen below. And though we see it right here, in their answer, they denied it. The response to plaintiff's first request for admission did not include the photograph which was specifically included in the request for admission and then went on to state, and this was the response, defense object to this request as vague and ambiguous on the grounds it does not define, identify, or otherwise clarify either the time, place, or manner of publications. Defendants further object to this request as vague and ambiguous on the grounds it does not define, identify, clarify, or otherwise refer to Fitznews' state of mind when making the subject publication, the absence of which also prevent defendant from truthfully admitting or denying this request in its entirety. Subject to and without waiving these objections, defendant admit that Fitznews published the photograph contained therein. To the extent this request attempts to obtain an admission that such publication was either intentional or purposeful, was done with malice, or was either actuated by ill will, nor with the design to causelessly and wantonly injure the plaintiff, or with such recklessness as to show a conscious indifference toward plaintiff's rights, defendants specifically deny the same. Goes on, this request very simply asks the defendants to simply admit or deny that they published the photograph seen above. The defendants instead provided an 8-line response objecting to the request as vague and ambiguous. They then state that the request does not state or refer to the defendant's state of mind when making the publication. But then the defendants go on to admit that Fitznews published the above referenced photograph. Therefore, plaintiff seeks an order striking all objections to this request to admit and compelling defendant to admit that Fitznews published the photograph above, and there is no dispute that it was published by Fitznews. So number 4, please admit that Fitznews was put on notice that this photograph portrayed Austin Stanley in a false light as seen in the below email. And it shows the email with the mom. The defendants once again did not include the photograph which was made a part of this request to admit in a blatant attempt to prevent the plaintiff from using these responses as an exhibit at the trial of this case. Tricky moves, you're not going to get those past Mark Tinsley. The defendant went on to state, here's their response. Defendant objects to this request as vague and ambiguous on the grounds it relies on an undefined phrase, falsely published, which is subject to more than one reasonable interpretation. No. It was falsely published. This guy was not the prime suspect. There's no interpretation. Defendants further object to this request as vague and ambiguous on the grounds it does not define, identify, clarify, or otherwise refer to Fitznews' state of mind when making the subject publication, the absence of which also prevents defendant from truthfully admitting or denying this request in its entirety. Responding to this request, defendants admit that Fitznews republished the photographs set forth therein. To the extent this request attempts to obtain an admission that such publication was either intentional or purposeful, was done with malice, or was either actuated by ill will, nor with the design to causelessly and wantonly injure the plaintiff, or with such recklessness as to show a conscious indifference toward plaintiff's rights. Defendants specifically deny the same. He goes on, once again, the defendants have refused to answer a simple and undisputed fact. There is no doubt that the defendants were made aware that the publication included a photograph of the plaintiff and that his mother emailed Will Folks, the owner of Fitznews, and told him that the publication was false. There is no doubt Will Folks knew the information was false, and he admits such in his email. Furthermore, there is no doubt that Fitznews published the same picture later on after it was made aware that the statement was false, because the defendants in the above response state, defendant admits that Fitznews LLC republished the photographs set forth herein. Therefore, plaintiff seeks an order striking all objections to this request to admit and compelling defendants to simply respond by admitting the request and including a photograph of the email included in the original request for admission. Just admit it. We all know it's true. Just admit it. Well said, my most favorite Low Country lawyer. Now that concludes our documents in this case for today, and I will be on the lookout for any new developments here. Thank you all so much for watching. Let me know what you think of all this in comments. I always love hearing from my crew here. And I apologize, I've been away a lot lately. I wish it was for happier reasons, and believe me, I'd much rather be here doing what I love to do with you guys. Till next time, this is Cassidy O'Connell saying stay well and stay tuned.